jury has to be convinced beyond a reasonable doubt that the defendant perpetrated a robbery. But if 3 victims say he held the gun to my head, and if the other 4 say, no, it wasn't a gun, it was a club, and some other victim says, no, it was a knife, the jury doesn't have to be unanimously persuaded that it was a gun or that it was a knife or that it was anything else, as long as they're persuaded that there was the element of force to commit the robbery, right?
Well, but
why wouldn't that analogy that worked for the Court of Special Appeals, why wouldn't that govern this issue?
But doesn't that question almost answer itself when you added the insertion of force? It's the element of force that brings about the robbery.
Well, their point is the crime of child abuse can be committed in a number of ways. A robbery can be perpetrated in a number of ways. The jury has to be persuaded to be sure that the crime was committed. But as to the means by which it was committed, that's a different issue.
Well, I guess I was going to add, we have the Rice, I think it's Rice, from this court, where we talk about, where we say that theft can be, the jury does not have to agree whether the person was the taker of the stolen goods or the receiver. 2 different means.
Yeah, but that's
2 completely different means.
Correct. That's part of it. It's built into the theft statute. That's the language of the theft statute.
Alternative ways of committing theft. Why isn't this the same? Alternative ways of committing child abuse.
Wouldn't the state have to prove each and every element of the child abuse statute? Wouldn't they have to say, well, we have an abuse? Wouldn't they have to prove each and every element of the abuse to satisfy? You wouldn't even reach the custodial component of the abuse statute until you satisfied the fact that there was abuse.
Are there cases from any other jurisdiction that agrees with this argument, that have precisely addressed this issue in the context of child abuse?
Not that we found.
Okay.
No questions?
Thank you, sir. Meyer.
Good morning, Your Honors. May it please the Court. I guess I'll address initially the issue of the unanimous jury instruction on the child sexual abuse charge. And I think the nuts and bolts of the challenge here is, at trial at least, Mr. Crispino and his counsel alleged that kissing in and of itself was not sufficient to satisfy the sexual abuse element of a child sexual abuse charge. I think that we've since seen that kissing is euphemistic for what actually happened in this case, and that under any circumstances, as this child described what occurred to her, that would satisfy the element.
I think we actually heard something akin to a concession on that.
Correct. And I think that was done in the Court of Special Appeals. If you look at one of the footnotes in the Court of Special Appeals opinion, that was the same. There was an agreement as to that fact. When you talk about the unanimity, then, with regard to child sexual abuse, what is it that they have to be unanimous? What is it that the jury has to unanimously agree occurred? And I think if we look at this Court's opinion in Cooksey, which talks, and I think Cooksey sort of serves as an umbrella over the entire argument in this case, but that the gravamen of the offense is not the act itself, it's the sexual abuse. And so the jury has to be unanimous as to the abuse. Now, what constitutes the abuse? I think we can all agree at this point in the argument that each one of those alleged incidents would suffice to allow for a finding of sexual abuse, i.e. the molestation or sexual exploitation of a minor. So in answer to Your Honor, Judge Murphy's question, I did not focus on and did not find any case that addressed the unanimity requirement when there's in a child sexual abuse continuing course charge as to what element there would be. I mean, I think the State would be this would be an entirely different argument if, in fact, we were talking about a peck on the cheek, but we're not. Might there be a requirement for a specialized verdict in that context. If you look at Richardson or Chevry or Gilley, as they're cited in the state's brief, I think you look at things with regard to whether there's a juror confusion or whether the methods of the violation are sufficiently different.
What if the judge, in giving a jury instruction, says to the jurors, now look, you've got to be persuaded beyond a reasonable doubt that sex abuse occurred here. But it doesn't matter whether you all agree or don't agree on precisely the act that constituted that abuse. You've heard evidence in this case of 4 different ways that it would be child abuse. And if 3 of you think it's the first way, and 3 of you think it's the second way, and 3 of you think it's the third way, and 3 of you think it's the fourth way, that's okay. Even if those of you who think it's the first way are persuaded beyond all doubt that that's the only way it occurred, and with respect to each of you.
Well, again, I'm going to refer to Rice and what this court did in Rice, and that is that, if the gravamen of the offense, here, the sexual abuse, there, the taking of the property, is the same, then what event led up to that finding it's the finding of the abuse that has to be unanimous. I think that's consistent with what the legislature, quite frankly, did in its continuing course statute, where the allegation is 3 or more, but there has to be no agreement as to which 3. So I think that's consistent with that instruction. And I think, again, I want to sort of get back to what the issue here is. And did the trial court abuse its discretion in declining to give an instruction that requested a unanimity as to as to which event? And it's the State's position that that was an incorrect statement of the law. And so for those reasons, the court properly denied giving that instruction. With regard to the second challenge, and that is the date of the offense, I think it's the State's position, again, that, and this Court has repeatedly said in Cooksey and Mulkey, that time is not an essential element of an offense. And it's, in essence, what defense counsel wanted was a unanimous jury verdict as to a non-element. And again, for that reason, the trial court appropriately declined to give that instruction. I think the confusion here is which Cooksey opinion controls. And Cooksey in and of itself is sort of like taking, I think at one point Cooksey said it's like trying to put a square peg in a round hole in a different context, but that's what's going on here. They're trying to take a case that deals with pleading and say, okay, we didn't challenge it for purposes of pleading. We didn't do what we should have done. We didn't ask for dismissal of a duplicitous indictment. We didn't run the risk of adding extra counts. So now we're going to try and fix this problem at the end to our benefit. And it's a fix that was proposed by the Court of Special Appeals in Cooksey, but rejected by this Court. And I think that's what's important. It's that the proposed fix, a unanimous verdict, allowing requiring the state to choose, pick which event it's charging or it's going forward on is.
Ms. Brockmeyer, what are the, I'll say, checks on the rule that you've just referred to, or the case decisions saying that time is not an element that must be proven? Surely there have to be some limitations on that rule when you think about what the defendant faces, which is perhaps needing to establish where he or she was on a particular date, or on the defense generally that I wasn't there. If time never has to be proven, how does the defendant ever prove he wasn't there?
Again, Your Honor, and I'm referring to this Court's opinions in Fulton, Yanch, Brummer, Hill, and Tucker, all of which are cited in our brief, which says the time is not an element. Now, I think Your Honor's problem is with regard to the pleading. Yes, there has to be some sort of reasonable particularity with regard to the pleading, and it's the pleading that protects the defendant with regard to, the notice provisions and And if the court looks at this court's opinion in Mulkey, even in the context of these child sex offense cases, there is a lot of leeway, and the absence of the ability to pick an alibi is really will not result in a dismissal of the charging document for lack of specificity.
Well, I guess I'm familiar, and I think not word for word with those cases, but with the concept, and I understand why, particularly when you're dealing with child sexual abuse, why the dates cannot be proven with a degree of specificity. But I'm just trying to figure out where the line is drawn between what's fair and what this court has decided is acceptable and just what isn't.
Well, right now the line is, I think, as Judge Murphy pointed out, when the dates, when a specific date is necessary for proof with regard to maybe the age of the child, or is it if it's a misdemeanor offense, if there's a statute of limitations problem, and so the proof then is part of the case itself.
But never when the proof is not a specific element of the crime.
And certainly not, you're not entitled to a jury instruction on unanimity as to that. And again, we're talking about a variance between what the charges say and what the child testified to. And in this case, some of those concerns aren't present because, quite frankly, this is obviously the second trial for this case. There was no I don't think there was any surprise on the part of defense counsel as to the lack of specificity with regard to the child's testimony or her inability to sort of pinpoint the date upon which this happened, or quite frankly, if you look at her testimony.
Let me just go back for a second because I'm just trying to understand. So your position is if it's not, say, a limitations problem or proving the age of the child, then there is no requirement that the state allege the date that the proof conforms to what is alleged. Is that,
if Your Honor's asking me a pleading question?
I think I am.
Okay. If Your Honor's asking me a pleading question, again, if you look at the cases, the cases are replete with, and particularly Mulkey, if you look at Mulkey, it's not, the time frame is not an essential element. You do your best.
What would
is
we
what
be,
you do.
Where would we be? There's another hypothetical. I asked them one. The jury is out deliberating, and they send the judge a note. And the note says, we're still working on the issue of whether he committed this crime. But all of us are persuaded, beyond a reasonable doubt, that if he did it, he didn't do it between the dates that it charged. What do we do?
Again, it's
how does the judge respond to that?
It's the state's position that the time itself is not an element of the offense. And so that what the jury needs to be unanimous with regard to is, did he, in fact, commit these crimes?
Okay.
And so with regard to, and again, I think the case law supports the state's position in this, and particularly, it's a kind of, it's very difficult to take Mulkey and Cooksey in particular, because they're both pleading cases, and to sort of take the jurisprudence with regard to that and ignore everything else, and say, okay, now Cooksey applies, at the end of the case. And I think as the trial court pointed out, the argument before it and the argument before the Court of Special Appeals, and quite frankly the argument before this Court, is that the Cooksey Court of Special Appeals opinion, where the proposed fixes were set forth, would have cured these problems, and they didn't, and they wouldn't, and this Court acknowledged that in its opinion in Cooksey. I want to just spend just a brief moment on the what appears to be a new challenge to this case, and that is the failure to give a unanimity instruction as on the third-degree sex offense charge, because the older child testified to two particular acts of cunnilingus.